But Ian Binnie, CC, QC, is currently counsel at Lenczner, Slaght, and as one of Canada's top and most respected litigators, went on for nearly 14 years as Justice of the Supreme Court of Canada. And when he retired in 2011, he was described by the Globe and Mail as arguably the country's premier judge, and by the press as perhaps the most influential judge in Canada in the last decade. During his time on the country's top court, as only the second modern justice appointed directly from the bar, Ian Binnie authored more than 170 opinions, including on landmark cases involving patent interpretation and validity, protection of trademarks, media law, commercial disputes, punitive damages, expert evidence, and many aspects of constitutional, criminal, and administrative law. Throughout his career as a litigator, Ian has often taken on public service roles as well. In the early 1980s, he served for 4 years as Canada's Associate Deputy Minister of Justice. He was later appointed Special Parliamentary Counsel to the Joint Committee of the Senate and the House of Commons on the Meech Lake Accord. An elected member of the International Commission of Jurists, he has appeared before the International Court of Justice and various international tribunals in government litigation matters, and has acted as Canadian representative in high-profile disputes involving France and the United States. Ladies and gentlemen, please help me welcome the Honourable Ian Binnie.
Thank you very much, James. Certainly a pleasure and honor to be here as a relatively recent defector from the dark side of the courts into the world of ADR. This recent arrival prompted me to pick as my topic Rumsfeld's Law, having to do with trying to differentiate between the things we know, the things we don't know, and the things we don't know we don't know. A lot of that, it seems to me, applies to the world of ADR. What I was surprised to discover early on is to what extent the mediators and arbitrators are targeted in this system as the weak link. I read an interview with a Carol Nairn at Skagnerps, who said that she's tired of arbitrators being recruited from the ranks of retired lawyers and judges who are, quote, looking for a cushy job between golf games, unquote. Quote, to be a great arbitrator is such a difficult job because you have to do all the things that judges do without the instant authority and gravitas that comes from having the weight of the state behind you. And it certainly is true that you feel your authority ebb rather quickly once you leave the bench and your opinions don't have quite the force that you thought was due to their merit, but which actually was due to other circumstances. Then another comment from the same colloquium: you can have the best musicians and score, but if the conductor plays out of tempo, harmony becomes impossible. So in entering on these mediations and arbitrations without the benefit of the authority of the state behind you, you're in somewhat of a vulnerable position. What strikes me this morning, hearing the growth of ADRIC over the years, is that when I went to the bench in the beginning of 1998, ADR was much talked about, but not widely practiced, except in things like construction industry and maritime law and special fields. And now it would appear that the legal community is overrun with mediators and arbitrators. You can't pick up a legal publication without pages of people holding themselves out as the world's greatest mediator or arbitrator, or this chamber's or that chamber's I looked in the registration list for today's conference to see if Harry Capito was in the ADR business. He turned out not to be. But the fact remains that there seems to be not a great deal of quality control mechanisms to assess the selection of arbitrators and mediators, which is something I want to come to briefly in a minute or two. I appreciate there's an accreditation under the Chartered Institute of Arbitrators, and I gather the ADR gold standard is going to develop domestic criteria. I was warned off getting the Chartered Institute qualification because apparently if you mess up, notification goes to 15,000 members worldwide of your deficiency. So better to fly below their radar. I have the impression that there is a good deal of self-deception in the ADR community. There is the myth, which is either genuinely shared or put about, that somehow ADR functions on relatively simple, predictable, flexible lines, in contrast to the costly, delayed, messed up, complicated court system. But as somebody looking at it with a relatively fresh eye, it seems to me that the ADR scene is not as simple as is pointed out or is portrayed. One of the big fundamental principles, of course, is that arbitration is based on the consent of the parties. But of course, in many different contexts, particularly the consumer context, arbitration is part of a package which is found in the fine print and may have bad results from the point of view of the unwilling party to the arbitration. There are many instances, it seems, where there is no privity of contract between the arbitrating parties. For example, under the International Settlement of Investor Disputes, the investor isn't party to any treaty. There's no consent to the International Convention, and yet they have the ability to take advantage of the arbitration provisions. But I think what strikes me in all of this as one of the issues about the consent and control of the parties over the arbitration is the apparently massive growth in third-party funding. There was a resolution at a conference in London last year that said third-party funding was the greatest thing since sliced bread, and it passed by an enormous majority. And it seems that since the 2008 financial crisis, there has been a huge inflow of money into third-party funding of arbitrations, looking for an investment return much higher than is available on the market. Well, when you have third-party funding of arbitration, in effect syndicating claims, there is a real issue, it seems to me, as to who is controlling the arbitration and to what extent does party autonomy apply in those circumstances. Then there is the notion about the, which is true, and all of these things are true about the ability to choose the arbitrator, but there are exceptions as well. And once the arbitrator is chosen, if you're within the rules, for example, of the ICC that Barry referred to, there is this practice of submitting draft awards to the court of the ICC for preliminary scrutiny. Now, I don't know what goes on in that process of scrutiny. It appears that quite often awards are sent back to arbitrators to give more ample reasons on this point, to decide that point that wasn't overlooked. But there are more people in the arbitration room than perhaps was bargained for. Then again, of course, one of the huge selling points of arbitration and mediation is confidentiality. And this, again, is true, but there are a lot of unknowns as to the limits of this confidentiality. Under some institutional rules, confidentiality is not automatic, although it will be imposed if requested by the parties. But there is a case now pending before the Supreme Court of Canada that many of you will be familiar with, between Union Carbide and Bombardier, where there was a mediation. There was an explicit term of the mediation agreement that nothing which transpires in the mediation will be alleged, referred to, or sought to be put into evidence in any proceeding. Well, the mediation was successful, and there was an agreement, and the parties agreed there was an agreement, but they couldn't agree on what the agreement said, whether it was limited to Quebec or whether it was a global settlement having to do with gas cans or gas tanks on skidoos and so on. When it was sought to enforce the arbitration or the mediation, the agreement arising out of the mediation, it was objected to because this required disclosing what had gone on in the mediation. And the Quebec court upheld the objection selon la juge France Thibault, qui a dit « Toute communication cesse d'être privilégiée si elle est nécessaire pour démontrer l'existence d'une transaction qu'une des parties cherche à établir. » So you have confidentiality up to a certain point, and the party that most wants it doesn't get it when it moves into enforcement. So again, yes, confidentiality is clear. Yes, it's a big advantage, but there seem to be a lot of unknowns as to when it attaches, to what extent it attaches. Then it is said that the mediation arbitration offers enormous flexibility, and so it does. But from what I see, the idea that the parties look for and achieve a short, sweet, no delay, expeditious, informal resolution is more honored in the breach than in the observance. Some of these things make lawsuits look as if they're on the rocket docket in terms of the complexity. Some of this is fed by institutional rules. The ICC rules, the LCIA rules are really quite complex. Much of it is left up to the arbitrator or the ICSID rules, to the mediator, but there is a cumbersome element entering into ADR which is antithetical to the basis on which it's promoted. And it strikes me as a danger facing the ADR community that the evolution of ever greater complexity can prove quite a disadvantage. And then there is the vaunted spirit of neutrality. Everybody says, even in arbitration, party-appointed nominees are to act in a neutral way. They are not to favor the party that appointed them. They are not to be seen to be favoring the party that appointed them. But then I was at a colloquium of in-house counsel, and everybody agreed that, well, if you appoint an arbitrator to a panel and the arbitrator doesn't bring home the bacon, well, that's no more work for that arbitrator. So the game of neutrality is talked up even in terms of the party appointees. But to what extent is it respected? To what extent can one regulate, control, know what is going on between a party-nominated arbitrator and the party? One of the in-house counsel at this colloquium said, well, you know, what I expect is if the thing is going badly, that my nominee on the board will give me a signal it's time to settle. Well, neutrality? I don't know. You have probably a lot more experience in these things than I do. All I say is that there are a lot of unknowns out there as to how these boards operate in the great complexity, particularly of international arbitration, where unlike within Canada, where there's a certain consensus as to how things should be done. Then on the question of enforcement, the ease of enforcement, particularly internationally, with the New York Convention. This is a tremendous selling point. And TCAS and the ICC recently circulated in triumph a decision of the BC court in CE International Resources, where the court enforced an arbitral award despite the opposition of one of the parties. But then about the same time, there was a decision in Qatar, and the Middle East is a booming growth area for international arbitration, commercial arbitration. And the court in Qatar refused to enforce the award because it had not been issued in the name of His Highness the Emir. Well, apparently that's a rule in Qatar, that this is the form in which an enforceable award has to occur. So yes, broadly speaking, there is a guaranteed enforcement. There's a little bit of wool around the public order exceptions. As you know, there's a lot of litigation in India as to just to what extent the court can refuse enforcement based on, quote, public order considerations. But again, there are unknowns lurking below the surface of the simple rule. So I want to deal briefly with a couple of these items in greater detail. I find the whole process of selection of mediators and arbitrators interesting because unlike the courts where there's security of tenure, arbitrators, mediators, you people are in business. You're entrepreneurs. You're sole proprietors in looking for this kind of work. What information is out there on which potential parties can select arbitrators? Is it all word of mouth? Are there databases? Is there a rating system? All of these aspects seem to be swirling about the courtship. I find very interesting the extent to which parties can interview prospective mediators and arbitrators outside the knowledge of the opponent. And it seems that there is some attempt to regulate this, but there are very differing views as to how far that goes. There seems general acknowledgement on some things. You can certainly asked about qualifications, about interest, about availability, you can certainly talk to the arbitrator about the party nominated arbitrator about the choice of the chair. But how close do you get to the substance of the dispute, and how is that relationship chaperoned, particularly in the international community, and again, this ever-present question of conflicts of interest. Now, what I like in the world of arbitration is the notion of, the big name arbitrators. They seem to be called the gorillas of the arbitration world. In the interstate investor-state arbitration, I read that 55% of all those arbitrations were handled by just 15 adjudicators. A tiny, tiny community. And where there are multiple credits to a particular arbitrator, 83% of those people came from Western Europe or North America. And one of the things you pick up in the literature of particularly international arbitration is growing dissatisfaction amongst the really growing, booming economies of Brazil, India, and so on, with this Western orientation to global arbitration. There is a feeling that the system has been co-opted by people who operate on a set of values on which there is no consensus. There is an increasing diversity in global arbitration that is not really being adequately addressed. Jim referred to my experience in the World Court and in international boundary disputes. And I want to refer to that a little bit because Yves Fortier was a very valuable member of the legal team of Canada in both of those disputes. And the International Court of Justice is much closer to ADR than it is to a domestic court. Again, there's no security of tenure for those judges. They have a term, but they're always running for re-election. So that when we were in The Hague on the Gulf of Maine dispute with the United States, pretty well every night, and this thing went on for 8 weeks, there was a cocktail party thrown by one or other of the judges, and you would be taken aside, and you would be looking frantically for somebody from the American team to come over to give a semblance of propriety. The judges didn't seem to care. They'd carry on talking about what had transpired that day. And you really had a sense that the International Court of Justice, as the arbitration community, they're looking for work. They're saying to the world, bring your disputes. Because outside of the compulsory jurisdiction provisions, which only go so far, they rely on attracting business, and part of the way they attract business is by fudging the rules. Because if you could predict the outcome of a case in the International Court of Justice, you wouldn't go there. If you're going to be on the losing end, why be like a turkey calling for an early Christmas? Why not just leave the whole thing up in the air? So it is quite unlike a domestic court, and I think informs my kind of appreciation of what is going on. Now, some years ago, when Jim Flaherty was Attorney General of Ontario, he developed this idea of a big scorecard for provincial court judges. He's going to have the judges along the y-axis and then sentences for offenses along the other axis. And he could then analyze who was tough on crime and who wasn't, with a view to favoring those who complied with his view of what ought to be done. And this was roundly denounced as interference with the independence of justice, independence of judges. No, but the reality is that it seems certainly large international law firms and others do keep a kind of scorecard of who is doing what. How many arbitrators always favor the party that appointed them? What is the feedback? Is a particular arbitrator more inclined to a kind of equitable approach to disputes, or a compromised result in investor-state disputes? Is an arbitrator generally favor a good deal of elbow room to a country to change its laws on the environment and labor and so on as a matter of public policy, even if under one interpretation of the investment agreement the investor is entitled to the old law. We had a very interesting example of this in the Gulf of Maine, and the arbitration panel was on Saint-Pierre and Miquelon. And in the Gulf of Maine, we have a very distinguished professor from the Sorbonne who was part of our team and who developed and pushed and presented and supported the equidistance method of boundary delimitation. You don't need to go into all the dreary details of it, but it favored Canada to say that the dispute with the United States should be resolved by a line equidistance from Nova Scotia and Massachusetts. That was great. We then come to Saint-Pierre-Miquelon, and equidistance is disastrous for Canada. Absolute disaster. Halfway from Saint-Pierre to Halifax gives an awful lot of maritime area to this little island of Saint-Pierre-et-Miquelon. Who turns up as the French nominee to the arbitration panel? But yes, the famous French professor who had mounted the equidistance argument for Canada, one of the people was our collective position, who said, well, I don't understand, Canada's opposition to equidistance back in the Gulf of Maine. That was your big thing. Well, I've no doubt that, the professor was acting out of conviction that this was the appropriate mechanism. But it did turn out to be rather convenient from the perspective of the party who appointed that individual. I don't know what goes into these rating systems. What is the quality of the feedback? But there's no doubt that the rating systems are out there and widely used. I mentioned a moment ago this, I find, interesting question of the courtship for party-nominated arbitrators. And the International Bar Association, which seems to have an inexhaustible fund of guidelines for practically everything, and which arbitrators seem to follow unless they're expressly excluded under the agreement, says that there should be no ex parte approach with a potential arbitrator regarding arbitration without the agreement of the other side, subject to certain defined exceptions. In a survey, and what is recommended is that there be, if there are ex parte discussions, that there be a record kept and that this be disclosed to the other side who was unable to be present. Well, this formed the subject matter of a survey by the Queen Mary School of International Arbitration in London. And it was found that notwithstanding the strictures of the IBA and the Chartered Institute, this was simply, in practice, ignored. That the potential arbitrators were being approached. There was all kinds of discussion off the record. White and Case, in its survey, said that 50% of the people responding said there was no need at all to make disclosure of these pre-appointment discussions to the other side. That whatever the IBA says, whatever the Chartered Institute said, they didn't accept it and they weren't going to do it. 90% of those who thought that there might at least be disclosure of the fact of a pre-appointment interview said they would never disclose the contents of what was discussed. Conflicts of interest, of course, a huge problem in the appointment of mediators, arbitrators, mainly arbitrators. And in the arbitration field, there seems to be this growing concept of the advance waiver of conflicts of interest, and one can see an enormous problem. Once an arbitration board is constituted and up and running, an arbitrator who is a member of a large firm, and this is mainly a problem with the big international firms, where the arbitrators haven't exited, as Yves Fortier and some of the others in this room have done. So the big firm takes on a client which offers a much bigger brief and a much bigger retainer and much more work than this little arbitration. And what is to happen to the arbitration? Do you put an end to the arbitration? So there's this theory developing that once the arbitration board is constituted, the arbitrators should require of the parties an advance waiver that if there is some conflict arising after the constitution of the board, it would be waived. Is such a waiver valid? I'm sure there are some features. One of the arbitrators acquired a financial interest in one of the parties. How could this possibly be covered by a waiver? But as we know, with these endless IBA guidelines, there are the red zone and the yellow zone and so on. What can be waived and what can't be waived. But there really doesn't seem to be any way of answering this question of advance waiver until and unless, as will probably inevitably happen, an award is challenged on the basis of bias and the validity of this advance waiver will be contested. Then in the conduct of the proceedings, well, I think the diversity of legal cultures now engaged in particularly international arbitration creates a problem, but even domestically, certainly there is an issue over oral discoveries, over the extent of document production. There are different views, not only at the bar, the parties, but also within the arbitration community. In terms of experts, again, going back to the Gulf of Maine, we had a fisheries expert produced by the United States. That was dealt with by a panel of 5 judicial figures. Yves Fortier was in charge of the fish and cross-examined the fisheries expert. We think he did a terrific job of demolishing this United States expert. We found out afterwards at the cocktail party that the civilians French, German, and Italian judges on the panel were shocked at the loss of face of this world-class expert, humiliated in an international forum. So they resented what we would regard as a highly successful demolition of evidence that was prejudicial to the Canadian case and put forward by the Americans as one of the linchpins of its argument. So, you know, when one leaves the legal culture that we all live in this country, there is a very a different set of expectations and rules governing how these things are to be conducted. And when I speak of diversity, of course, the arbitration centers just springing up everywhere. In the Middle East, I referred to. Mauritius now has a big center trying to cater to the African crowd. Jerusalem has developed a massive center. So there will more and more be a decentralization. Hong Kong, Singapore, enormous Asian practice. And, you know, Canadians are just going to have to get used to dealing with very different cultures, very different rules. Now, in terms of confidentiality, I mentioned this Union Carbide case. You know, but confidentiality has public policy limits. There have been a number of recent cases under NAFTA between private parties, you know, one complaining about government regulation of FedEx, another dealing with motor additives, somebody complaining against the country changing its rules on motor additives. And there's a large community out there that says these disputes go beyond the private parties. They involve public interest, and people have to be admitted to speak up for the public interest. You can't have these things determined solely by the parties within their own little framework. And that more and more has been accepted. Now, I want to just conclude with some observations on the known knowns and unknown unknowns. And just picking up on this problem of public interest. One of the really interesting cases going on now has to do with a claim against Cyprus by some Russian investors, saying that they ought not, that they are protected from the haircut, as it were, imposed by the European community on deposits over 100,000 euros as a condition for bailing out the Cypriot banking system. And these investors are saying they are protected by an investor dispute agreement from such state action. And this is defended, of course, on the basis this is public policy, this is a sovereign state trying to salvage itself. But as we know, in the case of Argentina some years ago, the state necessity in a financial crisis was given short shrift. I think there is an unknown as to the future balance between judicial intervention and judicial restraint. There is a concern that, as in the case of some of these consumer disputes, there are public interests at play which should limit the scope of private ordering, should limit the ability of the parties to say, this is our dispute, it doesn't concern anybody else, and it will be running according to the rules that we lay down, particularly when those rules are imposed by contracts of adhesion. There is a real issue about competence. yes, the general rule is that the questions of jurisdiction should go to the arbitrator. But the arbitrator is under no obligation to bifurcate and allow the jurisdictional question to go first. So you can get into a lengthy arbitration on the merits. The jurisdictional question is lurking. At the end of a long hearing, the arbitrator determines, well, I have no jurisdiction. Well, does this not suggest that perhaps the courts should not be quite so ready to relinquish to the arbitrator a ruling on the validity of the arbitration agreement in cases where there is a really serious question? Now, Barry Leon says this would be a violation of Canada's reputation of being arbitration friendly. Well, so be it. There are a lot of other considerations at play out there in the broader legal community. What about the situation where there are both arbitrable claims and non-arbitral claims? Supposing you act for Blake's, and Blake's had a contract with a computer supplier, and it's an arbitration clause. But then it turns out that shoddy computers were supplied, and it turns out that this is all part of a kind of a conspiracy, an alleged conspiracy among parts suppliers to provide shoddy parts to the supplier with whom you have a contract. You can go after that supplier, but what about your tort claim against the so-called conspirators? What is the court to do when confronted with claims that are collectively within the same fact situations brought against both somebody subject to an arbitration clause and somebody who is not? Another unknown is the extent to which, instead of having these arbitral agreements, there will be increasing resort to dispute boards. Now, dispute boards are very old, a kind of preset group of people who are agreed to by the parties to settle disputes. Sports events, construction projects, but increasingly, for example, in the financial industry, there are dispute boards. And to what extent will that model take over from what we are used to? And finally, the unknown is to the extent to which Toronto will realize its dream of becoming a global arbitral center. Geographically, Toronto is very well placed between the United States and Europe, sophisticated legal system, lots of qualified mediators, arbitrators, but as I mentioned, massive competition, a new facility in New York sponsored by a bunch of law firms to attract business, keep business in New York. Is Toronto going to make the grade, and to what extent are people in this room prepared to get out and push Toronto as a desirable place internationally for these arbitrations to take place, because it is a very lucrative and growing area of practice that Canada does not have a fair share of at the moment. Unfortunately, it seems that the ICC took about 50 years in order to build up to its present caseload of about 700 cases a year. There's a long timeline. Whether or not Toronto achieves in this global ambition is probably beyond the professional lifetime of many of us in this room. Thanks.